Hello, everyone. Today, our topic is Estate Planning 101. We're going to be discussing some of the basics to estate planning and what you need to know as far as estate planning is concerned. Um, as an attorney, I think that it's the best practice to just be in the business of educating clients. And I tried to provide educational resources to the community on my website. And this video is in a series of videos that's on my website called viclaw.org. That's the website, viclaw.org. And today our topic is Estate Planning 101. We want to go through some of the basic documents that I think everybody needs to have. And then we'll make mention of a couple other documents that at least should be considered in the estate planning process. And we want to keep things very basic here and just kind of give a brief overview of estate planning so that we kind of have a background, maybe an overview to begin with. So first of all, what is an estate? An estate is any interest you own in real property. It could be land, it could be the attached buildings on the land. Usually you think about the house, that would be real property. You could think about maybe rental houses that you have, maybe a farm. All of those things are part of an estate, but it's not limited to just real property. It also includes cash in a bank account. It could be cash in your house. It could be, some of the household items that you have, stocks and bonds, retirement accounts. Those also make up the estate. And so all of those items need to be considered when formulating an estate plan. You don't want to have a plan that only focuses on land without dealing with retirement accounts. You don't want to just focus on retirement accounts, but then not have a plan for the land or for rental property or for the house. You want to have a comprehensive plan in place when you're doing your estate planning that deals with each one of these specific properties one by one. So that's what an estate is. And estate planning is about planning ahead. And there are a lot of different reasons, a lot of different motivations for estate planning. One of the biggest ones is protecting and providing for the surviving spouse. If a husband passes away, what is going to happen to the wife's financial situation? Or if the wife passes away first, what will happen to the husband's financial situation? That becomes especially important when you're dealing with income planning. For instance, a pension that a husband may have. What's going to happen to the pension if the husband passes away first? Is there going to be enough left for the spouse to make it? And if not, what plans do we need to put in place so that if that happens, we can prevent disaster? And maybe it's not just a spouse, maybe there are children involved. What's going to happen to the children if both parents pass away? What do we want to happen for the children? If we have minor children, do we want the minor children to be with the mother's family or with the father's family? Who do we want to name as a guardian of the children? Do we want to have a trust in place so that the children have a trustee that is overseeing the funds for the children and providing for them? So that's one motivation for estate planning. Another is to avoid family conflicts. When the children were growing up, I imagine that parents had some disputes that they needed to settle. Maybe they were fighting in the sand. The children were fighting in the sandbox, and the mom had to come out and figure out who was at fault, who was in the right, who was wronged, and had to to settle it and make peace. Um, and unfortunately, it seems like if there's not a specific plan in place where the parents have stated exactly what they want to happen upon their death, families have conflict, and it's important to have uh, provisions in place that sort of foresee what's going to happen with the family, and make appropriate recommendations or mandates to the children about how things are going to be settled. Another reason is to provide for special needs individuals. If you have a special needs child, a special needs grandchild that you want to receive inheritance, what's going to be the impact on their government benefits if they receive a lump sum? What do we need to do to prevent a loss of government benefits for that individual, and then supplement those benefits with a special needs trust or something like that? And then maybe a purpose is to leave a lasting legacy. It may be that um, a parent has come to retirement age, and maybe they've done some traveling, they've done everything that they want to do, and they're just really ready to settle down, and they have a some money that is set aside, and they're not really using it. It's kind of dormant. What can we do with that to make sure that that is protected and is not going to be diminished any before a person's passing away? And the reason for that is to leave a lasting legacy. Maybe it's to take to provide for children going to college or grandchildren going to college. Some of those are some of these reasons are reasons to do estate planning, are very common in the clients that I meet with. So protect and provide for your spouse and children, avoid family conflicts, provide for special needs individuals, and leave a lasting legacy. All of those are reasons to do this. And then what documents should we all have at minimum? Well, first of all, I think everybody needs to have a last will and testament, and preferably a last will and testament that has a contingent special needs trust. That's particularly true in when planning for a husband and a wife. If a husband is, for instance, in a nursing home, what happens if the wife passes away and then the wife's property ends up being the husband's property? Is that going to impact government benefits? It probably will. And is that a result that we can live with? If it's not, then maybe we need to have a contingent special needs trust so that there's no loss of government benefits if a spouse passes away. And then durable financial power of attorney. This is probably the most practical document that you need to have, because it comes into place so often. For instance, when a parent gets sick, is in the hospital, can't make decisions for himself or herself, that durable financial power of attorney is going to be there to help the family get things done. And then the healthcare power of attorney. This is going to allow you to make decisions for a person that's in the hospital or at the doctor's office, and be able to talk to those medical professionals. And it's important to have a HIPAA authorization as a part of that healthcare power of attorney, so that the hospital or doctor sees that and knows that you have that authorization. And then a living will, which states your preference as to end of life decisions. We'll talk about that just a little bit here in a little while. Let's delve into these documents a little bit deeper, and we'll start with the last will and testament. A last will and testament is a written document signed in the manner prescribed by law, and which disposes of property upon death. Here in Indiana, the law requires that two witnesses who watch the testator or testatrix sign the will while in his or her presence. So the witnesses have to be in the presence of the person signing the will, and then the witnesses also have to sign the will. That forms a valid will. But then there's an additional step that Indiana has taken, and that is to have a self-proving affidavit. So if you only had witnesses that were signing the will, stating that we've seen this person sign the will, um, that wouldn't necessarily be enough to probate the will. Those witnesses would actually have to appear in court and testify in front of the judge that so-and-so on this date signed the will in our presence. We saw him or her do this, and this is the document that he or she signed. Instead of having to do that, and you can realize how difficult that would be, Indiana allows for a self-proving affidavit where after everybody signs the will the first time, they sign it again to sort of seal it up and make sure that everybody knows that we really meant to sign this will, we really witnessed it, and this is our testimony under oath that this is a valid will. So that is what is necessary in order to have a valid last will and testament. And it disposes of property after a person has passed away. But that's not everything that a will does. A will can also nominate who you would like to be responsible to administer your estate when you die. We sometimes think about this as an executor or a personal representative. Um, Executor or executrix is sometimes the old school word for this administrator or this personal representative. It's more often that we call this person a personal representative, but a will is what you need to nominate somebody to handle your financial affairs after death. A will can also nominate guardians for your minor children. So um, even if you don't have a big estate, maybe you just have a house, maybe just an apartment, but you have kids. It's important to have a last will and testament, not necessarily for property reasons, but for guardianship reasons, so that you can name who in particular you want the court to appoint as guardian of your kids and take care of them if the parents have passed away. Another thing that the will does is that it can determine when and how your devotees will receive the property you leave to them. Maybe you don't want your children or your beneficiaries to receive everything all at once. Maybe you want to space things out a little bit. A last will and testament can do that. And then a will can determine how taxes are paid, if there are any taxes that need to be paid, and then it can employ tax saving strategies. You really think about this when it comes to estate taxes. Estate taxes are not very common now because if you have $11 million or more, that's when estate taxes really come into play. But that rule is always subject to political dispute. That law has changed many, many times over the last 15 or 20 years. And so it's important to have a will updated in order to determine how things are going to be taxed. So those are some of the other items that a last will and testament can cover, not just the disposal of property after death. A will must be probated in order to be effective. And by probate, I mean that there's a court process that has to take place. This probate process takes place after death, upon sufficient proof that this is your last will and testament. We talked about how you had to have these particular witnesses, and they have to testify under oath that they truly saw the will being signed by the testator, and everything is apropos. And then there's a court determination that this will meets the requirements under the law to be administered, and then that's the probate process. And when that occurs, the court has some oversight over administration. And here in Indiana, there are two different kinds of administrations. There's unsupervised and supervised. With an unsupervised administration, you don't have a lot of court involvement. There's some, you've got to go to court to get authority to be personal representative, and then there are some requirements regarding inventory um, and accounting, but largely the court is hands off. In a supervised administration, you have to go to court to get permission to do anything and everything that takes place in settling an individual's estate. And it's a public process. Anybody can look up what the last will and testament says, and figure out what that person wanted to do with his or her estate planning. It's a very, very public process. But one thing that a will does not do is that it does not provide provide any help for you while you're incapacitated during your life. So you plan a last will and testament, you execute it properly and everything, but it doesn't come into play until after you have passed away. Are there other challenges that occur, financial and otherwise, prior to a person's dying? Of course. Legal things that have to be taken care of. And so a last will and testament does a lot of good things after a person has passed away, but it's not very helpful when it comes to a person during his life. What about trusts? You may need a trust, you may not. It just depends on your situation. Trust is a private agreement between a settlor and a trustee to manage trust assets in certain ways for the benefit of a beneficiary. A trust may be revocable or it could be irrevocable. Revocable means that you can change it. You can put property in, you can take property out. Usually when a person has a revocable trust, he or she is the trustee of that trust, and it really operates as if there were no trust. Or if there's an irrevocable trust, you're probably not the trustee of that trust. Somebody besides you is going to be the trustee. And that may be a family member, maybe a friend. It's somebody that you trust. When you have an irrevocable trust, you're limited in your access to the property and the control of the property. But there may be some reasons why you would want that irrevocable trust. Maybe it's for tax saving purposes. Maybe it's for long-term care planning purposes. And it just depends on your situation whether that's the right thing for you. A trust can have more than one beneficiary. So you could set up a revocable trust, maybe you call it a family revocable trust, and your children, maybe you have 4 kids, each one of those kids can be a beneficiary under that trust. And you might even find it prudent to have a trust, what's called a subtrust, for each one of the children under this larger family trust, in order to protect assets. A trust may be written or oral. Obviously, it's better that the trust be written rather than oral, so that there's no dispute as to what the provisions of the trust are. One of the main things is that a trust is a non-probate instrument, meaning you're not anything that is in a revocable trust or an irrevocable trust typically is not paid into the estate when somebody passes away. So if it may be to our advantage to place items into the trust so that we don't have a probate estate. We don't have an attorney fee that goes along with the probate process, and everything can happen very smoothly outside of the very public process of a probate administration. And then you can also have what's called a trust protector. And this is somebody that sort of oversees the trustee's actions taking place with regard to the trust. And the trust protector may be able to step in if there's ever a dispute between the trustee and the beneficiaries and can make a decision. And maybe the trust protector can be authorized to name somebody to make distribution, to basically name somebody to make distribution to the beneficiaries. So perhaps you have a trustee that's running the day-to-day operations of the trust, but then the trust protector names somebody to come in and make distribution to the beneficiaries. And there are some long-term care planning advantages to that, that can really save when it comes to Medicaid planning and VA, Veterans Affairs, aid and attendance planning. Special needs trusts, or sometimes called a supplemental needs trust. This type of trust protects a disabled beneficiary's eligibility for government benefits. We kind of hinted at this earlier, that when a person is, for instance, on disability, maybe is receiving SSI, so supplemental security income due to a disability, you don't want that person to lose his or her government benefits. But if that person receives a lump sum, that happening is probably going to negatively impact that person's government benefits, and that person may lose the government benefits for some time. So what we would want to do is set aside a special needs trust, and money that is designated for this beneficiary goes into that special needs trust. And then there are rules that are in compliance with Social Security regulations that allow for a special needs trustee to make distribution to the beneficiary without negatively impacting the government benefits. Having that kind of trust can really provide a higher quality of life for the beneficiary. And it provides a framework for the care and management of assets. You can write it exactly into the trust how you want the trust property to be used, so long as it's in compliance with the disability regulations. It allows the parents to express their desires. It protects assets from creditors and predators. You've got somebody that's managing money for a beneficiary. That's going to help avoid any creditors getting to the trust assets. And then also it's going to prevent maybe people that are around this beneficiary, this disabled person. It's going to prevent those predators from coming and taking advantage of that person. And obviously, since they are special needs, perhaps they are more prone to being taken advantage of. And so you would want somebody to be responsible, somebody that is responsible to be taking care of the special needs property. And it extends the life of the assets. You can do a lot of different strategies as far as extending the life of the assets and making sure that a person has what they need. Durable financial power of attorney. This is a document that empowers your agent, an individual or a company, in some instances, to act on your behalf in financial transactions. Usually it's a parent that names a child to act on the parent's behalf in financial transactions. There are two different kinds of financial powers of attorney. One is a springing power of attorney, and the other is an immediate power of attorney. With a springing power of attorney, there is particular condition that has to be met in order for it to become effective. A lot of times it is the evaluation of a doctor that states that this person is not able to take care of himself or herself um, any longer, and thus the power of attorney becomes effective. But sometimes you just need to have an immediate power of attorney. Let the child or whoever you want start making those decisions immediately, so that there's no question as to whether it's effective. So an immediate power of attorney allows your agent to act on your behalf immediately whenever necessary. And then the word durable and the phrase durable financial power of attorney means that the power of attorney stays in effect after the principal becomes mentally incapacitated. The general rule, strangely enough, is that if you just have a power of attorney, it ends upon incapacity. Well, that's not really why we want a power of attorney. We want it to continue throughout the incapacity. And so that's why it's called a durable power of attorney. A healthcare power of attorney with HIPAA authorization is also an important piece to estate planning. This document empowers your agent to act on your behalf to make medical decisions. And it can also authorize your agent to make end-of-life decisions. Just like the financial power of attorney, this power of attorney can be either springing or immediate. It just depends on what the client wants. Springing requires proof that you are incapacitated. Immediate allows your agent to act on your behalf whenever necessary. And then a living will. A living will is a document that states your preference as to end-of-life decisions regarding nutrition and hydration when death is imminent. It authorizes your healthcare representative or your whoever's making that decision to allow you to die naturally. This document works in coordination with your healthcare power of attorney, and so it's really the healthcare power of attorney that is the authorizing document, and then the living will is instructive to the healthcare power of attorney individual, and tells the individual what exactly your preference is as to end of life decisions. So to kind of sum it up here, comprehensive estate planning, if we're going to try to get everything that we possibly can to plan for our estate, then we should have a last will and testament with a contingent special needs trust, especially in spousal cases when there's a husband and a wife. Also, a durable financial power of attorney, healthcare power of attorney, living will, and then if it's appropriate, we may want to have a standalone trust. It could be a special needs trust. It might be a revocable trust or an irrevocable trust. With an irrevocable trust, we may be able to make some planning moves that are going to allow you to save a whole lot of money if one of you, if one of the spouses gets sick, or if you're not married and you're just an individual, we can save a lot of money if we use an irrevocable trust. And you would want to do those for Medicaid planning or maybe even Veterans Affairs pension planning. So a trust might be appropriate depending on your circumstances. But at the bare minimum, I think you need at least these three documents: a last will and testament that has a special needs trust in it, and then a durable financial power of attorney and a healthcare power of attorney, so that especially those last two, if you get sick prior to your death, if what happens prior to your death is sometimes more important than what happens after your death. If we don't get that piece right, then what happens afterwards is probably not going to be right either. So durable financial power of attorney, healthcare power of attorney, those are really, really important so that if you're unable to make decisions for yourself while you're living, somebody that you trust is in place to make those decisions. And then a last will and testament to dispose of your property in the right way, provide for minor children with a guardianship, name the proper personal representative of your estate. All of those things are documents that, at the bare minimum, every adult person needs to have. I appreciate you taking a look at this. If you have any questions, feel free to reach out to me. I'll be happy to answer any questions that you have. Again, take advantage of the video library and the blogs that I have posted on viclaw.org. I believe you will find both the blog and the video library very helpful with a lot of information. And if there is a topic that you would like for me to do a webinar on, I'll be happy to take your suggestions and do a webinar on that topic. Just feel free to reach out to my office and be happy to help out.